Yes, may it please, your Lordship. Lord, in regard to item 24 and 25, my learned friend Mr. S.C. Biswas, my Lord, I am told he filed an affidavit on behalf of the informant. The copy has not been served yet. So, my Lord, I just requested him to, he told me that he'll be here, but then I don't find him.
24 and 25.
24 and 25, a short accommodation, if your Lordship fix it on 9th of February, my Lord.
24 and 25, right?
24, 25.
How about next week? Some
Beg your
difficult.
pardon me.
Next week, how about next week?
Yes, next.
CD is received?
CD is there.
Alright. If you can manage next week, that will be
Yes, yes.
better. Okay.
My Lord, can it be on 9th?
Next
Yes.
week is,
My Lord, can it be, can your Lordship fix a date?
I can fix it. Uh, uh, 24 and 25. An accommodation. And the Land Council for the informant will furnish a copy of the objection to petitions. Case diary retained. Case diary received shall be retained. Interim is there.
Interim is there.
Interim shall be extended till the next. How about fixing it on 6th?
My Lord, if it is on 12th, my Lord, it will be convenient.
So the diary will be stuck up. 12, I would prefer, if you can accommodate, 12, I would prefer next week if possible.
6th, my Lord.
6th, is it okay? For you?
All right.
Okay.
Much obliged.
On 6th.
May I please, your Lordship?
Yes.
Well, I beg to mention item 49, my Lord, the hearing matters.
Yes.
Well, I have some personal difficulty today, my Lord. I'll leave the court, man. So, my Lord, kindly, if possible, my Lord, that on 12th February hearing day, my Lord, maybe fix.
Hearing, okay.
12th February.
On 12th.
Item 49.
May it please, your
I'm
Lordship.
blessed, man.
With the consent of the other side, I beg to mention item number 41 of today's list, your Lordship. I am having some personal difficulty today. Can I make it taken after 2 weeks, your Lordship?
Order matter.
Order matter and the service upon the respondent has not been completed yet.
Not
Though-
complete.
And though
41 after 2 weeks.
Lordship,
On a date to be fixed by registry.
Lordship.
Your Lordship, yesterday, the case number criminal review petition number 322/25 was fixed at 2 p.m. Yesterday. But since
Oh,
the court seat up to, kindly fix it.
For mentioning, you're mentioning it.
Yes.
Right. When do you want it?
Second, third, or fourth. Whatever.
Let it be on 5th.
Obliged.
Yes. Otherwise, we could have taken it up yesterday. On 5th.
May it please, your Lordship, I beg to mention item number 47. We have filed for an additional affidavit that may be called for.
Item 47, additional affidavit may be called.
May I please, your Lordship? I
Yes.
beg to mention item number 52 of today's supply list, Lordship.
52.
Yes, Lordship. We are directed to file one additional affidavit, Lordship. We will be filing it today, Lordship.
You're for the
Petitioner, Lordship.
petitioner.
Yes. The matter may be come up after 1 week or 2 weeks, Lordship.
Petitioner means that additional affidavit would be fine. And fix an adjournment for 2 weeks, which is allowed. Please the matter after 2 weeks. Should we fix a date? Suggest a date after 2 weeks. Thirteen.
It's obliged.
13.
May I please, Lordship?
Yes.
Item number 10, Lordship. 10.
Item 10.
English Council has some personal difficulties. Next week may taken.
After 2 weeks?
Yes.
No problem. List after 2 weeks on a date to be fixed by the registrar. Any interim order?
No.
May it please, your Lordship, I beg to mention item number 27.
27.
The CD has not come yet.
Mhm.
CD has not come yet.
CD is not received.
No.
Issue reminder. Interim is there.
Yes.
Extended. Interim is extended. Is the matter on suggested date? 24 people.
Much obliged.
Right.
May it please, your Lordship. Lordship, with the concern of the other side, I beg to mention item number 23, my Lord. Lord, this matter may be taken up next week, my Lord.
Bail cancel.
Not next week, Lordship. Last week of February.
You're
Lordship.
for,
I'm a petitioner, your Lordship.
you're for the respondent. For bail cancel.
Yes, Lord.
So you want it after 2 weeks.
Lordship, last week of February, Your Lordship.
No.
This is the matter, adjourn for the date, this is the matter. In the, should I fix a date?
Yes, Lordship.
Uh,
26, Your Lordship.
yes, 26, the rain date, 26 or 27?
Lordship,
26 or 27?
26 will be.
26 too.
Yes, Lordship. All right, Lordship.
May please, Your Lordship, I beg to mention item number 9 with the consent of the other side. Lordship, may adjourn this matter for today, Lordship, and fix it after in the second week of February, Lordship. May I pray for a date?
Adjourn for the date. Any interim orders?
No.
List in the second week of February would be, how about 16, just after the second week?
Lordship.
16 too.
All right.
May I please, Your Lordship? I beg to mention item number 43 for Ashton.
43. Another. Adjourn for the, when do you want it? After,
After 2 weeks,
after 2 weeks. Date to be fixed by registrar.
another for listing Lordship. Regular
Tomorrow, or Monday.
Monday.
May I please, Your Lordship? My lord, in item number 12, the opposite party has filed objection petition. And
Where-
it is
Which
not
item number?
12.
Huh? 12.
12, yes, my lord.
Okay.
So I may be allowed to take it.
You want to file a
Yeah.
reply?
No, the objection petition, it is not taken. My lord.
It's
The
not,
opposite party has,
NCB.
Yeah.
NCB. You have received the copy.
yes, yes, my lord.
So what is your prayer?
The opposite party has filed a objection petition and it is not taken.
Oh, it is not here.
Yeah.
In the record.
Yes, yes, my lord.
Maybe brought in.
My lord, please, can we fix it after 2 p.m.?
We can, not fully understood actually, the record, the objection is not in the record. Oh, or should we wait and let it come up? The matter, and I'll be take a call. Don't worry, take a call.
May I please, Your Lordship, my lord? May I please, Your Lordship? My lord, item number 6, my lord, my name should be strike out, my lord, as the party has taken the file from me, my lord.
Okay.
And Wakalatnama should withdraw, my lord.
You want,
That is
your good name, please?
Kedi Chetri, my lord.
KD Chief, Learned Counsel for the respondent.
Yes, my lord.
Respond number 2.
Yes, my lord. One, sir.
Respond number 1 submits that he has decided to withdraw the wakalat number. As the he is seeking to withdraw the wakalat. Prayer is allowed. The party has. We
Party
will
has
engage
taken.
another, otherwise we will have to issue a notice. It's
Yes, my lord. That is
not adjourned.
with respect, my lord. I'll respect, my lord.
May it please, my lord, may it please, Your Lordship.
Yes.
My lord, I beg to mention item number 7, Your Lordship.
Yes.
I am with the petition, Your Lordship. The connecting council has some personal difficulty to the Your Lordship. So humbly seek for adjournment, Lordship. Kevin, sir. Admission matter, Lordship.
Adjourn for the date. When do you want it?
After 4 weeks, Lordship.
After 2 weeks?
After 4 weeks, Lordship.
So let us fix a date.
Lordship.
25 to
Lordship.
little later than 2 weeks. Or if you want it earlier, 18 to.
Lordship can be after 4 weeks.
Yes, to 18 to.
18
to.
Lordship. I'm deeply obliged.
No, just has to be struck. So we have to issue a notice. Today, it does not appear to another council.
Please, Lordship. Lordship, I have been in custody for 76 days till today. And the case is connected to item number 19, Lordship. In item number 19, CD is available, Lordship.
So this matter may can taken up along with 9.
Along with 9.
Wait, please, Lordship. Lordship, regular bail application earlier rejected by Lordship. This is the second time bail application, Lordship. Today, 82 days. And Lordship, it can be taken up with item number 22, arising out of the same FI, Lordship. Listed today.
CD not received.
However, updated CD was called for.
Not received.
Today, 82 days, Lordship.
Nice. So, we have to issue reminder in that and
Yes,
call for the CD.
yes.
Shorter date because it's
Shorter date,
already
yes.
82 days.
Well, Lordship, we fix it on 5th or 4th, any day.
Yes.
Yes.
Fourth, will it-
Fourth, Lordship. Fifth time will be available, Lordship. Fourth.
which Thana?
It is from Tinsukia. Makumbi.
Will it come? Will it will come? Call for the case diary of Makum PS case number 50 of 2025. The present petitioners are in custody since 10/11/2025. It's fairly submitted that this is the subsequent bail petition, an earlier bail petition on behalf of the accused was rejected on. What is the earlier?
Earlier order, Lordship will find it. Page number 65.
Rejected on 18/12/25 and BA 3909. List the matter on
4th of February.
4th of February along with BA
Along with my lord, item number 22, my lord, BA 187/2023.
187 of 2026.
Oblige.
Yes.
Make please, Lordship. Here also, Mala, it is the second application, Mala. At this stage, I pray, Mala, Lordship may call for the uploaded case diary, Mala. Only that, Mala. From Bongaigaon.
Sam Abdul. Call for the, it's fairly submitted that this is a subsequent petition, earlier petition 8/1/26. BA 4071 of 22. Call for the up-to-date, updated case diary. Bongaigaon PS 290 of 25.
Mala, earlier order at page 24, Mala. 9/1/20.
Yes, list on,
On my lord, 16/2,
is it okay? Or
16
I want it earlier.
16th, then my lord on 13/2.
You want it earlier? It's still earlier, it's okay.
On 10/2, my
10, Mala, 10. Oblige your Lordship.
Lordship. Lordship, this is an anticipated bail application, Lordship, arising out of Mankasar PS 87/25. This is the second time we are filing it. Lordship, may call for the case diary. FIR is in page number 18. The select copy is in page 12.
Second bail petition earlier 25/11/25 AB 2593 of 20. Call for updated case diary Mankasar PS 87 of. This also you fix on the same day.
Yes,
What date? 10,
10, 11/2, my lord, 11.
11/2.
11.
Masupla.
May it please, your Lordship. Lordship is an anticipatory bail application, an incident of 14/11/25, where now the apprehension of the petitioner herein as other co-accused, the name person in the FIR, they have already been granted PRS bail. And now what has happened, there is an apprehension, these are small people and farmers, there is a fear among the village that he might be disturbed or police may harass him. In such circumstances, he has approached before this court. Otherwise, Lordship, if the FIR at page 11, there is a dispute with regard to the installation of meter as alleged. And then on the third paragraph, it states subsequently the mob get out the APDCL vehicle, a mob that may be marked, and physically assaulted the in charge and other staff members. 2 staff members were beaten severely and 2 mobile phones were damaged at the spot. Upon receiving the information, I immediately sought your assistance and with your prompt help, the APDCL team was safely rescued. That is actually the matter. But ultimately, as prayed by this officer, such allegation has been brought. And Lordship will kindly take this annexure to page 16. There, your Lordship, there's a particular finding where it says that the learned so-and-so has submitted that as per the case diary,
The alleged injuries received by the victims during the scuffle are simple injury. Although the scuffle has been referred to by some of the witnesses regarding the other petitioners,
They registered that APDCL exercise, whatever.
this but and the statement of the petitioner, he was not there, he was there in the farming land. Subsequently, he came to know. And the name itself has been reflected wrongly, therefore. Nonetheless, and other petitioners has been asked to appear today.
Son of Abdul Hamid. He's not named in the FIR.
His name four.
I think
Case number 4. Kayam.
Yes.
Okay.
Wrongly.
Correct.
Father's name also wrongly shown, but others have been directed to appear today before the IO.
Page 17 of. Yo, Mr.
K.M. Mohanta.
AM. The council submits that few of the FIR named accused persons were granted interim anticipatory interim bail, not interim, final anticipatory
Disposal.
bail by coordinate bench of this court on 21/1/26 in AB 2969 of 25. It is submitted that petitioner self. The petitioner denies the allegations and self render its cooperation to the investigation. Call for the case diary. However, in the interim, to enable the petitioner to record his statements when same. 3,000. List the matter on
my lord, 25-2, my lord. 25-2.
25-2.
Oblige, Lord.
May it please your lordship.
Yes.
Lordship, the petitioner number 1 is assistant teacher and in charge headmaster of AMA school. And the petitioner number 2 is a retired head constable.
Head constable.
Head constable. Lordship, the FIR is at page 9, my lord.
Page 9.
Page 9. May I read, my lord?
Yes.
It is respectfully submitted that accused number 1 is the husband of my sister-in-law and accused number 2 is my maternal uncle-in-law. On 24/10/2025 at night around 12:30 a.m., the two accused named below called by saying that they have something to talk. I opened the door and they entered the house. The accused number 1 forced me to the bed and tried to rape me. When I tried to resist the accused, he threatened me, tore my clothes, touched my chest private part, and pushed me away. On my shouting, and my minor daughter and neighbors came forward and both the accused ran away. This is the FIR, my lord. My lord, the actual fact is that the informant's husband and the informant's family-in-law, my lord, they are having some long-standing dispute regarding the property, my lord. And even after the registration of this FIR, lordship, the incident is alleged of date 24/10/2025 and the FIR is registered on 21/2025. That is after 58 days, lordship. It shows that the issue is manipulating, lordship. And subsequently, lordship, recently on 25/1/2026, the dispute regarding the property, lordship, which has been settled. And now the informant is willing to withdraw this case. Since the case is non-compoundable in nature, lordship, she has also submitted a affidavit before the IO that will be perused by this honorable court at page 14, my lord. 14. Page 14 is the affidavit by the informant. Relevant portion is page 15, my lord. Para 1 I am reading. I am the informant in the FIR which has been registered as Gauripur PS case 530 on 21/12/2025 at Gauripur PS case, District Dhubri, Assam, under section so and so against BNS. Para 2, my lord, that there is an old pending dispute between my husband, namely Johuruddin Ahmed, and in-laws family member regarding share of their landed property. The same is now settled between us by a separate agreement. Lordship, now para 7, my lord, the last paragraph. That I have no objection if IO of the case will submit the FR in the aforesaid case against the accused person, or Honorable High Court is pleased to quash the aforesaid FIR. My lord, at this stage, lordship, since I am the assistant teacher, lordship, as the FIR has been filed after 58 days of the alleged incident, lordship. Till the perusal of the CD by this honorable court, I may be protected in interim bail, my lord. And lordship, may I submit, even before this affidavit and registration of this case, lordship, several meetings were held, lordship, for the dispute. And those resolutions were also submitted before the police station, lordship. I have also obtained the copy of the resolution. One of such resolution was under the guidance of former minister, lordship. If this honorable court wants, may peruse it.
Mr. Karim,
R. Karim, my lord.
or Karim, learned counsel.
I would just like to submit only one thing. Let him appear before the my lord, arresting authority regarding that.
Definitely, my
But regarding only one direction, officer, regarding the genuineness of, let him submit a copy of that affidavit before the IO.
Yeah.
And IO will verify
Original,
that.
I don't know whether he has.
Original has been submitted. I have stated in the petition, lordship.
Let him submit before.
Let him submit the.
Definitely, my lord.
IO will verify the genuineness.
Definitely, my lord.
482 R Karim and additional report. 482 bail application, Gauripur PS 530 of. The petitioners stated to be the relatives of the informant / victim only, who lost the FIR on 17/12/2025. With the full stop. The gist of the allegation that on the night of 24/10/25, the petitioners came to her house and tried to outrage her modesty and tried to come to their residence and tried to rape her, threaten her, semicolon, that they tore her clothes, touched her chest in private, pushed her. The learned counsel submits that both the parties have a backdrop of land disputes, and that the allegations are false and concocted. It is submitted that the FIR has been lodged for 58 days of the alleged incident. It is submitted that after the registration of the case, the property dispute between the parties was settled, and the informant tore an affidavit on so date stating 25/1/2026, stating that the dispute has been settled and that she lost the case due to some misunderstanding, and that she does not object to she has no objection if the IO submits FR in the case. Call for the case diary, however, in the view of the aforesaid facts and circumstances. In the interim, it is direct 20,000 operate district here before. SL. Also submit copy of the affidavit before the IO for verification. This is the matter on
26/2.
26/2.
Yes.
Sorry, Lordship. In item 2, Lordship has passed the order, Lordship. Item 2 and 22 are connected, Lordship. And 22 is fixed for bail hearing, Lordship. So it would not be proper to pass. And 22 in item 22, different counsel is there, Lordship. So both the matters can be taken up when item 22 is called up, Lordship.
Just a minute, I'll get confused. I think someone appeared.
Yes, I appeared in item 2.
Okay.
2 and 22 are connected.
Okay.
22 has come up for bail hearing, Lordship.
Yes.
And 22 different counsel is there, Lordship.
Different counsel is.
So 2 and 22 both can be taken up at when the item 22 is called up. Would be better, Lordship.
Case diary is not come.
Not there.
Already your lordship has fixed.
Yes,
matter
Lordship,
on
but
4-2, my lord.
if an counsel is there, would not be proper to pass order in his absence.
Okay, I understand. Now I
Yes,
get
Lordship.
it. No,
When-
problem.
When 22 is called up, both the matters can be taken up.
if possible, you also be there.
Yes, I will be there. I will be
We'll
there.
work it
Lordship.
out.
Obliged.
51.
My pleasure, Lordship. Lordship, this is a PRS bail application, my lord. Page 9 is the unregistered FIR, my lord. Till date, we are unable to run through the registered case, my lord. Page 9, my lord, kindly page 9. May I read, my lord? Respectfully begs to state that 1/9/126 at around 3 p.m., my elder brother, namely Shahjahan Ali, while selling fish at Dapna Singh Shaura, this is a name of a place, my lord. The accused number 4 came from backside and thrown sand in the eye of my brother. After that, the accused number 4 caught and hold my brother, and accused number 2, 3, 4 started to assault my brother by kick, fist, etc., and injured him in the different parts of his body. While my mother, Jalimun Nessa, has come forward, the accused number 1 assaulted her also. At present, my brother and mother is under treatment at FAM hospital. Proof and evidence of incident is available. This is the, my lord, allegation. My lord, kindly peruse again, my lord, page 12. My lord. Here is one undertaking, my lord. I'd like to read out also. 1/14/12/25. I, Abdul Salam, 39 years, son of Abdul Latif, resident of village Situli Police Station, Borpeta District, Borpeta, Assam, mobile number so and so, had submitted one application to the officer in charge of Bagbar Police Station in respect of my missing wife Munwara Khatun. On the basis of said application, Bagbar Police rescued my wife and handed over to me. Accordingly, I have taken her custody. For this purpose, I will not lodge any case. I will not harass my wife in any manner. We both will continue our matrimonial life peacefully. We agreed this in the presence of the local respected person, my lord. And second para, this said by Munwara Khatun, also same, my lord. My lord, this FIR actually lost by the informant by based on the some vague allegation, my lord. Earlier, one incident was happened between these two parties. The undertaken shown by Abdul Salam, who is the present petitioner number 1, and second one, Munwara Khatun, who is the petitioner number 4. This Munwara Khatun and informant's brother Said Shahjahan Ali developed illicit relationship. And in order to that relationship, Shahjahan Ali taken away my wife Munwara Khatun. And after that, I have lodged a case before the police station, and accordingly, police rescued my wife from the custody of the Shahjahan. And after that, we have settled the dispute. Subsequently, my lord, again said Shahjahan, on the present day of occurrence, my lord, present FIR, day of occurrence, my lord, again tried to take away my wife. And at that moment, accused number 3, who was the village Gabura, he see the incident, he informed us, petition number 1, 2, and 4, 1 and 2. Then we reached that place of occurrence and restrained the informant's brother Shahjahan Ali to take away my wife, my lord. And at that time, some altercation was took place, and in days of said altercation, he lost this present case. But at this moment, my lord, we are unable to get the registered number. However, Bagbar police, my lord, continuously searching us. Thereby, my lord, I am preparing this anticipatory bail application without case number, my lord. And kindly report may be called for from the police station. And in the meantime, my lord, I am seeking interim protection. Why I am seeking interim protection, my lord? Today, my lord, in my house, one religious occasion is organized, that is Urus Mubarak, organized in my house today, my lord. And so that I can appear, attend my said religious my lord, occasion without any fear of police, my lord. I am seeking some protection, my lord, to that extent only, my lord. And kindly a report may be called for.
Well, I will get the report, my lord, on Tuesday, my lord, I can get
Yeah,
that.
Learned counsel for the petitioner. Doing. A.K. Azad, learned counsel for the petitioner. P. Bottom, learned additional people. Invoking 482 BNS, the petitioner is seeking anticipatory bail in connection with a complaint lodged by one Rashida Khatun before the Mondia outpost under Bagbor PS. It is however stated and submitted that no case has been registered as yet. 4 accused persons, including all the 4 petitioners. The 4 petitioners are the fire named persons. And the allegation is that on 9/1/26 in the afternoon, the informant's elder brother was selling fish at a place when accused number 4, Manowara Khatun, came threw sand in his eye, whereafter she caught hold of him and the other accused persons. Accused number 2, 3, and 4 started assaulting him. The learned counsel has drawn attention to one undertaking made by the said Manowara Khatun and submitted that in the context of one illicit relationship between her and the aforementioned Shahjahan Ali, he had Abul Salam had lost the case and the police recovered his wife, and this undertaking was done. Subsequently, when the said Shahjahan Ali again tried to take away the said lady, there was an altercation, and this complaint has come to be filed. He submitted that he shall cooperate with the investigation and seek some interim protection in the context of a religious function at his house today.
Today, yes.
Call for a report from the Bagbor PS as to whether Bagbor PS as to whether any PS case has been whether any case has been registered with regard to the same said complaint, and if so, the particulars of the same and case diary may also be sent.
Yes,
That-
if raised, yes.
Case has not been registered. Report thereof may be sent. However, in the meantime, the petitioners shall not be subjected to any coercive measures by way of measures. And however, they are at liberty to appear before the IO, making them available for examination. That's all. We cannot give a bail actually, isn't it? Because there is no PS case.
That
Yes,
was
no
sufficient, my lord. No course action, that is also
Only
sufficient.
till my lord, till 4th of my lord,
Fourth?
February, till 4th of February.
Fifth,
Yes, till 5th of February.
No course action, my lord. Till fifth.
Only till 5th of February.
till the next date of listing, till the returnable date, no coercive. Fine tune. List on 5/2.
Yes, ma'am.
I'm obliged, my lord.
May I please, your lordship? Lordship, in this matter, we have filed our objection, but it is
Yeah, that
not
was
in
the
the
mention in the
record,
morning, yes. So
Lordship.
you have filed an objection.
Yes, your
Right,
lordship.
right.
They have already
The
filed.
objection may be called for.
So today we cannot take it up.
Today itself we can
We
bring
can
it.
take it. The objection may be called.
I will-
Item 12. Objection filed by the. May be called. We'll take it up after something.
All right.
May it please your lordship. Lordship, this is a regular bail application, lordship, 51 days in jail custody, lordship. Statutory period is 60, lordship. What happened? Yeah, young boy, lordship, 22 years, and the girl is 18 years. FIR, lordship, will find on page 13, lordship. Elope because of love, and they are, lordship, from different religion. That's why, lordship, in the girl is recovered there on the next day, lordship. I have in forwarding report. It is reflected on page 16, ground number 7, lordship, 9, lordship.
No, he's on interim, right?
My lord.
Yes.
Equal.
Diary has come,
Not, no, there is not received.
not received.
Not received.
Next time. Case diary as called for has not been received. Issue reminder for the same. The interim bail granted by the order dated 8/1/26 stand extended till the next date of listing.
Highly obliged.
This is the matter on
My lord, 19th, my lord.
19/2.
My lord.
You can give a little later also if you want.
My lord.
Little later also. 25/2.
My lord, 25.
19,
Hello.
25.
25.
25.
Can it be 26 or?
Okay.
Yes.
What is the lordship, my lord? One of the petition applicants, my lord, she is the wife, my lord. The deceased person's, my lord, is the husband, my lord. So today, my lord, as on date, my lord, she is in custody for about 42 days, not 42. 22 one, nah? So
48
about
days.
48 days, my lord. So, my lord, the affair is at page, my lord, 12, my lord. So basically, it is a on, my lord, this is basically on suspicion, my lord. With due respect, these to inform you that on 12/12/25 at about 5 p.m., Umendra Nath Bora, son of so-and-so, resident of so-and-so, was found lying dead in his house. On being informed by the villagers over phone, I visited the place of occurrence, and after discussions with the family members and the neighbors present at the scene, I came to know that the deceased so-and-so and his wife has been quarreling for a tough long time. Hence, the villagers suspected the deceased wife so-and-so had killed her husband. So basically on suspicion, my lord, yes. My lord, we have made a categorical statement, my lord, that the husband, my lord, is suffering from epilepsy, my lord. So basically it's a case, my lord, my lord, the husband, he is alcoholic, my lord. So, my lord, every time, my lord, there was a quarrel between them, my lord, in the evening hours, my lord. In the forwarding report also, my lord, the ground of arrest, my lord, if lordship sees, my lord, ground number 3, my lord. In the statement recorded under 180, the accused admitted that a fight had occurred between the accused and the deceased on the night of so-and-so. During the fight, the deceased pushed her, causing her to fall to the floor and injury her legs. In retaliation, she pushed him back, caused the deceased to fall onto the bed, my lord. So she put her to the bed, my lord, and sustained injuries on his face, particularly around his eyes and nose, my lord. So every time, my lord, this is the, my lord, I have make a categorical statement to that effect, my lord. So every in the evening, my lord, both the teachers, my lord, of a school, my lord. Both the teachers, my lord. And now today, 48 days, my lord. And it is apparent, my lord, the wife will not, my lord, kill her husband, my lord. Or it is, my lord, if at all it hasn't happened, my lord, maybe due to epilepsy, my lord, it may happen, my lord. And there was a fight, it is admitted position, my lord. The quarrel, basically, my lord.
My lord, here I have received the case diary, my lord. Here PM report also received, my lord. Here PM report is, my lord, not conclusive, my lord. Cause of death is kept pending till the receipt of viscera analysis, FSL. But it is also not received, my lord, today.
Poisoning.
My lord, that is regarding or alcoholic that is, my
I
lord.
can have a look.
My lord, here lordship may kindly perish here, my lord. But in the PM report also some, my lord, injuries are there, my lord. In the face, neck, my lord, cheek, etc. My lord, lordship may kindly one entity statement of the witnesses, my lord, also there, my lord. Lordship may kindly perish. Some injuries are in the dead body, my lord. The PM report also, Lordship, may kindly pay. Some injuries are there.
Bruises,
4, 5, my lord.
contusions and bruises.
My lord, injuries are there.
That may not be a cause for death of a person.
Heard
GLM.
learned counsel for the additional people. Invoking 483 BNSS, the petitioner Basanti Gohai is seeking bail in connection with Panigaon PS case number 88 of 25 under 7 protection. He was arrested on 13/12/2025. Connection with this case, which was registered based on an FIR dated 13/12/2025. So the gist of the allegations is that pursuant to a quarrel that the petitioner is suspected to have killed her husband / the deceased. So, on the forwarding report, it appears that there was a quarrel followed by scuffle, and in the context of the same, the incident took place. The case diary has been received. PM report indicates some contusions and bruises. The statement of one witness recorded under 183 BNSS is available. Peruse the same. In the progress of investigation. The given facts and circumstances, and also considering the length of detention, the progress of investigation, I deem it fit to grant bail at this stage. Accordingly, the petitioner is allowed to go on bail of rupees 20,000 with one surety of the likeness, with the satisfaction of the concerned learned court, which will be which court? Lakhimpur.
It should be allowed, CGM allowed, not Lakhimpur. No?
CGM not looking within bracket. Concerned learned court
Lakhimpur,
within bracket CGM Lakhimpur,
Yes,
not Lakhimpur. Stop. And subject to the conditions that we shall cooperate with remaining investigation and not hamper or tamper with it. Return case diary. The petition stands disposed.
Obliged, man. Highly obliged.
Motion.
But please, Lordship. Petitioner is on interim bail, my lord.
Yeah.
My lord, here charge sheet submitted, my lord.
Okay.
Delay done, no?
Starter group.
179. Okay.
Take it to the phone. Yeah.
Let him appear before the court below, my lord. As charge sheet submitted, my lord.
Report. Length of detention. The case diary was,
My lord, charge sheet submission, let him appear before the court.
there's an interim regular bail.
My lord. Till his appearance, man.
Same thing. The learned additional PP submits that in the meantime, on completion of investigation, charge sheet has been submitted. And further submits that perhaps the petitioner may be directed to approach the learned court. Nevertheless, in view of completion of investigation, I deem it to allow this bail application accordingly. The interim bail granted by order dated 9/1/26 hereby made absolute, subject to the condition that the petitioner shall be available for trial if on commences, and she shall not hamper and tamper with evidence. Violation of bail conditions will make the bail liable to be cancelled. Standard. Bail petition stands allowed in this post.
Charge sheet number is there, my lord. 5/26. dated 9/1/26.
charge sheeted by CS number, CS number,
5/26 dated 9/1/20.
91.
16 is the same order.
Same.
Malad. Out of the same affair, Malad.
15, 16, same.
Okay, same order. Same order.
All right, Malad.
Allowed and disposed.
My lord, up-to-date case diary was called for, my lord. 70.
My lord, CD not received, my lord.
Case diary not received. Full stop. Issue press. Issue reminder for the same. The interim bail granted to the petition by order dated 9/1/26 stands extended till the next date of list. List on
25th, my lord.
25th. 25/2.
25th.
Obliged.
Please, your lord. My lord, a regular bail application, my lord. My lord, in earlier occasion, your lordship granted bail, my lord. And after obtaining bail, he appeared before IO, my lord.
Interim bail was granted.
Yes, my lord.
Here also CD not received, my lord, from San Mari PS.
So may I say, my lord, it may be absolute, my lord, he is cooperating with the IO, my lord.
But that information also not available with us, my lord.
Hmm?
But that information also not available with us, CD not received.
Issue press, CD not received. Issue press, issue reminder. Interim bail by 9/1/26 stands extended till the next date of list.
26
matter.
minutes. 26 2.
Obliged, my lord.
90, along with one.
May it please, lordship. Lordship, I have been in custody for 76 days, lordship.
19.
And earlier, two co-accused were granted bail after 55 days. And this is the order is page number 22, lordship.
Let us see the FIR.
My lord.
13/11.
13.
Where is the FIR? Page?
Page number 12, lordship. 10, lordship. 10. 10. May I read, lord?
Go ahead.
With due respect, I would like to draw your attention that today, that means 13/11/2025, the below noted accused persons belonging to Muslim community equipped with message and spear broadcasted news on various news channels threatening to cut off indigenous people and drown them in river. The news has drawn attention of indigenous people raising concerns to serious communal disharmony, which may trigger communal clash, hampering fraternity among the mass. Therefore, to brought the accused persons under purview of law and punish rigorously, and also to tackle and diminish possibility of such situation in future context, I kindly request you to consider register a case and take necessary action against the below noted accused persons. Is that correct? My only two accused persons' names are there, and 5 accused persons' names are not mentioned in the FIR, lordship. And length of detention is 76 days, lordship. Earlier it was granted after 55 days, lordship. So grounds of parity, lordship, may kindly be considered. And
So was not named in FIR anyway.
My lord. During
Investigation has progressed. No?
my lord. I have received the case there, my lord. During investigation, their names came out, my lord. And all of them, my lord, what happened, my lord, they are with a deadly weapons, my lord. Came out all of the accused persons and he sent the indigenous people, my lord, to cut and throw in the Brahmaputra river, my lord. That's the allegation, my lord. Because during the investigation, I was collected sufficient material, my lord. All of them involved in these activities, my lord. And I have the objection, my lord, granting bail to them, my lord. And parity is not the consideration for each and every cases, my lord. Here, either although it was given to he was 70 years old, my lord. That's why perhaps lordship was pleased to grant him bail, my lord. But here, all the witnesses and co-accused persons implicated that all of them involved in this case.
One person was 70 years old, but another was not 70 years. He was not granted on, he was granted only on the
both
length of
bail- In both the bail petitions, the persons were arrested on the same day, 15/11.
Yes, Lord.
15/11.
And Lordship, another thing is that section 152 is not maintainable in this case, Lord. Sedition is not maintainable. This is sedition, Lordship.
That's sedition.
Against the integrity and unity of India, Lordship. But this is against the community, Lordship. 152 is not maintainable in this case. So punishment is 7 years punishment.
Can I have the diary?
No, fine. এখন দিন।
If not, item 19 on. Go to page 20. You will find the steps. So. Like. M. Rahman,
M. Rahman.
Learned Counsel for the petition and additional people.
Number
Please, you can take, they were arrested on 15/11.
15/11, both the cases, madam.
These 22, 23, this para 2, 3, 4. 2, 3, 4 you can take. Mr. Rahman, Learned Counsel submits that the petitioner has already spent 78 days in custody. In
76 days, Lord.
76 days in under trial detention. And also submits that another co-accused, Mujibur Rahman, was
And Abdul
granted
Malik.
bail, on 9/1/2026 by this court in BA 4086 of 2025, a copy of which has been annexed with the bail petition. The learned additional PP objecting to the grant of bail submits that the case diary has been received and investigation has found implications against the present petitioners, and the statement from the statements of the witnesses and investigation materials. Also, the petitioners are found to be involved in the alleged offences. Can I have?
I have given it. In the last part, my lord, my kind of statement.
Crazy people are there.
My lord.
Frankly speaking, we should not take them very seriously. But if they try to commit violence,
My lord, is
then we
also-
should take it seriously.
My lord.
Any. Reviewed the relevant portions of the case diary and seen the progress of investigation. Perused statements of some of the witnesses. The investigation does reveal implication against the petitioners, against the petitioner. However, considering the length of detention and the progress of investigation, I am of the considered view that perhaps bail can be granted, subject however to suitable,
The strict condition, my lord, may be
Condition.
imposed.
suitable and
There-
suitable conditions.
Refrain from doing such, my lord.
In such view of the matter, the petitioner is allowed to go on bail of rupees 50,000 with one surety, the like. And in the other one, I must have imposed certain conditions.
Item number 1.
50,000 with one surety of the like amount, satisfaction of this thing. The conditions will be same, cooperate with remaining with the condition, you need not write, shall not hamper, shall not misuse the liberty to commit any illegal activity or offense, including any activity to damage public
Right.
peace and social harmony.
CJM Nagaur.
Listen,
Worship, item number 1 also.
item same.
Same, lord. Same.
Highly obvious.
What to do now? Return back the case diary,
My lord.
petition stands disposed.
Obliged.
May it be pleased, your lordship. Lordship, this is a regular bail application. Lordship, petitioner is in custody for 82 days, lordship, and co-accused already got bail, lordship, on 9/1/2026.
My lord, first death case was came in the last yesterday, my lord. CD is perhaps in the.
I've actually completed the order, but I CID.
Purohit, bail paise.
I have
No,
already disposed it.
Hi.
Disposed of.
हाँ, एक तो जगह हाँ जो ठीक है तो already bail paise to co-accused.
I have corrected it.
It to 20 of
It's same case.
same PS number.
Yesterday's item, my lord, 47.
Okay.
47, 48. 49.
So you page 37. Your good name, please.
Rituparna Borua, my lord.
RP Purva. Okay. Second and third paragraph of the- Paragraph also. This is a subsequent bail petition.
Subsequent bill, after rejection, my lord.
Earlier was a,
It was earlier rejected by CGM, lordship.
not
Here, lordship.
Lord. I have signed those, actually. I have not signed. No, I have not signed. I've corrected. The bails have been allowed, actually. It's also same.
Highly obliged.
Please, your lordship. This is a regular bail application. also. Informant Your Honor, Durga Bora lost FIR against the Jinto Gogoi lordship. FIR, original FIR page number 21 lordship.
Here, CD, in the present case, my lord, case diary received, my lord. CD, Kogamuk PS1.
One more case?
Yes.
Bail application.
No, my lord, only one case, two case diaries were called for, my lord. In the present case, my lord, CD received. my lord.
First case is
Kogamuk-
there, lordship.
Ogamuk 1 of 26 and 2 of 26.
Yes, one received, my lord, one is the present case, my lord.
One is the present.
Along with injury report also.
Okay. What happened actually? What is the allegation?
Actual allegation is that lordship,
They were celebrating New Year.
new year lordship.
And then
Then the informant,
Durga Bora.
the previous enmity is there, lordship, petitioner wife lordship, in the year of 2022 lost FIR against the informant lordship. Charge sheet was submitted lordship, case is pending, district and session judge Dhemaji lordship.
Petitioner's mother. The
Lordship,
petitioner's mother lost
no, petitioner wife lordship,
petitioner's wife.
lordship. Case is pending before district and Dhemaji lordship, district and session judge Dhemaji lordship.
and case is fixed for argument on T 31 2026 Lordship. And that's why this case is lost FIR against me, Lordship. Number of occasion informant threatening the petitioner as well as his wife, Lordship, to withdraw the case, Lordship. And therefore, this loss FIR. Actual case is actual fake on the date of 1/1/2020 after having a picnic on 1st January, Lordship. The petitioner was returning home on his motorcycle. At that time, informant was already hiding there, waiting for assaulting the petitioner. As soon as the petitioner reaching the front of Jintu Gogoi house, in the informant Durga Bora strike him with a lathi. The handle of the lathi hit his face, and the petitioner fell down. After that, he was struck on the head with a dowel and also injured his body and hand, Lordship. Upon receipt of that incident, Lordship, we lost the FIR against the informant, Lordship. Upon receipt of the said Azahar Gogamukh PS registered case as a Gogamukh PS number 2/2026, Lordship. FIR page number, Lordship, 36, Lordship. May I read, Lordship?
36.
36.
This is the cross FIR.
This is the cross FIR.
You can read it. Yeah, read.
এজাহাৰকাৰী বিনি নিবেদন এই যে মোৰ স্বামী শ্ৰী জিন্তু গগৈয়ে 1/1/2026 তাৰিখে জয়ামপুৰৰ পৰা নিজৰ ঘৰৰ অভিমুখে আহি থকাৰ অৱস্থাত ৰাতি প্ৰায় 7:30 মান বজাত 1 নং আছামী ঘৰৰ সন্মুখৰ পথত আছামীয়ে পূৰ্ব পৰিকল্পিতভাৱে খাপ পিটি ৰৈ লাঠিৰে হাতত চোকা দা আৰু লাঠিৰে লৈ স্বামীক আগভেটি ধৰি দাৰে আৰু লাঠিৰে আক্ৰমণ কৰি মটৰচাইকেলৰ পৰা বগৰাই পেলাই দিয়ে। স্বামীক জখমী অৱস্থাত আছামীয়ে টানি চুচৰাই নি জিন্তু গগৈৰ ঘৰলৈ লৈ আছামীৰ আত্মীয় 4জন মানুহৰ সহযোগত দলবদ্ধভাৱে স্বামীক পানে মৰা উদ্দেশ্যে পুনৰ দা আৰু লাঠিৰে উপৰ্যুপৰি শৰীৰ মূৰ সোঁ হাত চকুৰ তলত সোঁ হাতৰ দৰে দাৰে প্ৰহাৰ কৰি ও লাঠিৰে শৰীৰৰ বিভিন্ন ঠাইত গুৰুত্ব জখম কৰি অচেতন কৰি স্বামী ঘটনাস্থলীত পেলাই ৰাখে। আছামীগণে ঘটনা সংঘটিত কৰাৰ পাছত ওচৰৰ চুবুৰীয়া উপস্থিত হৈ ঘটনাস্থলীৰ পৰা আছামীক উদ্ধাৰ কৰে আৰু আমি যোৱাৰ উমান পাই আছামীগণে ঘটনাস্থলী এৰি পলাই যায়। জখমী স্বামীক তাৎক্ষণিকভাৱে উদ্ধাৰ কৰি ব্যক্তিগত বাহনেৰে গোগামুখ চিকিৎসালয়লৈ লৈ নিয়া হয় যদিও চিকিৎসকে গুৰুত্ব জখম দেখি উন্নত চিকিৎসাৰ বাবে সেইদিনাই লখিমপুৰ চিকিৎসা মহাবিদ্যালয়লৈ প্ৰেৰণ কৰি লৈছিল। This is the FIR. Upon receipt of the said Azahar,
This medical report is of whom? At page 39.
My Durga Bora.
petitioner loss.
Let's
Petitioner. Petitioner loss.
And there's any medical report with regard to this present petitioner? Is there any medical report pertaining to Jintu Gogoi?
Jintu Gogoi loss.
Jintu Gogoi, alleged history of physical assault. So it appears that there's physical assault on both sides.
Yes. Well, otherwise, in this case, is there is.
Yeah. Shall we dispose it of without the other CD or should we wait for the other CD?
Lordship, may I dispose it of, my lord. This is the injury report, my lord. Grievous injury of Durga Bora and injured eyewitness, my lord. Nibha Gogoi's statement is also 183 statement is
He
available.
was arrested on 9/1.
Yes.
9 loss.
Grievous injury.
Previous enmity is there, loss in number of occasions threatening.
Stitch or left fatal region. Neck issues, spreading. Head injury is there. Referred to neurosurgery. Head injury is there. Statement of Mridul Dhingia.
Statement of my lord Nibha Gogoi, one of the injured witness. 183 BNS is also available.
City Chutia, learned counsel for the petitioner, and P. Bothago, learned additional bit. And the invoking 483, petitioner Jintu Gogoi and Smolov Gogoi seeking regular bail in connection with Gogamuk PS case number 1 of 26 under sense of same section. He was arrested on 9/1/26. The allegations, gist of the allegations in the FIR dated 2/1/26 is assault, causing injuries also. It is submitted that there is also an FIR on the side of the petitioner regarding assault, with regard to which Gogamuk PS case number 2 of 26 has been registered. Both the case diaries were called for, but only the case diary of Gogamuk PS case number 1 of 26 has been received. The learned additional PP submits that the medical report of the victim, who is this? Nibha Gogoi.
No, madam, Durga Bora.
The
Nibha Gogoi.
main victim of the informant Durga Bora indicates grievous injury, including head injuries. I have perused the said medical report. Statement of one of the injured witness, namely Nibha Gogoi, has been recorded before learned JMS. In the said statement, she is stated about the accused petitioner herein assaulting on her head with a dowel, leading to injuries. So, considering the materials, the fact that investigation is going on, the bail petition stands rejected at this stage. Return back the case diary.
Lordship, page number 44, Lordship. Can we go to the page number 44, Lordship? Medical treatment is required, Lordship.
Fracture is noted is right nozzle bone, Lordship. Page number 44, Lordship.
Essential treatment is required, Lordship. He is judicial custody, Lordship. Page number 44, Lordship. Fracture, Lordship.
This is the photo of Jintu Gogoi.
Jintu Gogoi, Lordship.
How come? He was also badly injured or what?
Lordship.
But Alice history of physical assault, but there's no narration of the nature of injury.
Lordship, kindly go to the page number 44, Lordship.
So we have to add. The learned counsel submits that in the incident. Is it the same incident?
Same incident, same day.
Incident. Petitioner was assaulted and injured badly. In support of the same, he has drawn attention of the court to the annex photographs, which reveals cut and bleeding injuries on the face and nose. Attention has been drawn to page 44 of the bail petition, which is a report of CT scan. It indicates fracture on the anterior wall of right maxillary sinus. Of the patient Jintu Gogoi. Thus, the findings of medical investigation correlates with the photographs. So in that case, we may have to take a different view. He was also badly injured. Broken. Yes.
Kindly allow, Lordship, as on day behind about 20 days, Lordship.
The learned counsel submits that granting of bail will facilitate treatment. Will facilitate the petitioner to take proper treatment. Despite the implicating materials, I find force in the said contention. Accordingly, considering the medical situation of the petitioner, he is allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction of the concerned learned court, which will be CJM Dhemaji, subject to the condition that number one, he shall cooperate with remaining investigation, shall not hamper or tamper it with shall not take law into his hands and shall not commit any illegal activities or offences. Return back the case diary. Bail petition stands allowed and disposed. Or can you cut it? Okay. He's badly injured.
Highly obliged, Your Lordship.
22, allowed to.
May I please, my lord? My lord, till today, 82 days in custody, my lord. My lord, what happened in this case, my lord, the deceased, my lord, he has molested one girl, my lord. And thereafter, my lord, the public there, they have assaulted and then he was, my lord, arrested and sent to jail, my lord.
22, my lord, case
In-
diary, my lord, already along with item number 1, my lord, this matter already
No, two.
2 years, my lord, fixed on 4th of February.
Or just a minute. Case diary, actually, there was a yeah, you were there, no?
Okay.
The case diary is not received in the other case. So, you can make your submissions. We had fixed a date, but if necessary, we'll modify it.
My lord,
Because he made a submission, I thought that's common submission, so.
my lord, my submission is that, my lord,
So
till-
we fix a date. If necessary, we'll modify it.
My lord, my submission is that, my lord, till today, 82 days in custody, my lord. My lord, in this case, what happened, my lord, one person has assaulted a girl, my lord.
This incident.
Thereafter, my lord, he was assaulted, he was arrested and then he was sent to jail. In jail, my lord, his condition deteriorated.
He died.
He died. Thereafter, my lord, the family of the deceased has lost his FIR. And my lord, this petitioner is the owner of auto rickshaw, which he was driving at that time, my lord. And my lord, earlier lordship rejected my bail. That since the investigation is going on, my lord.
That's okay.
And my lord, the IO,
Yeah, please.
and my lord, IO has submitted the objection in the earlier stage, my lord, where it is, in the order it is reflected, my lord, the victim died due to assault as well as negligence of the jail officer, my lord. So my submission are 82 days in custody, my lord, and my lord, he is the owner of the auto e-rickshaw, my lord, which the deceased were driving, my lord.
And
My
the
lord-
other one, in item 2, he's completed how many days? Same day?
82 days.
Same
My
day.
lord, considering all these
Same
aspects, your lordship earlier rejected the bail application and your lordship was to fix the matter on 4 to for updated CD. My lord. In the meantime, I will get the instruction, my lord.
Yeah, because he's 82 days, kindly get it.
Yes,
Dated case diary.
on
On 4th,
4th of February.
3rd or 4th.
Yes, 3rd.
Let it be on 3rd, my lord, because 86 days on that.
Ali. Case diary is not received. So, issue reminder for the case diary. It is submitted by the learned counsel that the petitioner has already spent 82 days in detention. Case diary shall be sent positive for the next day. Please don't. Whatever, 3rd,
3rd, yes.
will it come? Makum.
3rd, 4th would be convenient
would be
because
safer.
3rd, yes.
4th. Will
Obliged.
2 and 20.
2 and 20.
Obliged.
Mr. Gupta. Okay. Oh, 4, 2.
What was it? Then hearing 26.
First.
Twenty-six CD, my lord, available, man.
CD is available.
CD available.
May it please your lordship. Lordship, senior counsel, Digona Das has some personal difficulties. Lordship may, if possible, fix a short date,
On Monday or Tuesday.
Monday or Tuesday, lordship.
Monday. CD is received.
CD received.
Monday is lordship. 2nd, yes.
Okay.
Yes, sir.
At the council.
Lordship, can it be on 3rd, if possible?
Just your good name, please.
Mr. I. Bhuyan, lordship.
At Bhuyan, learned counsel. Amidst that, 6 an accommodation on behalf of learned senior counsel Dinas. Praise for listening the matter on 3rd. Case diary, however, is received and shall be retained. Is the matter on?
Lordship, on second only, Lordship. Second only, Lordship. Much obliged.
Two.
Two, yes. Much obliged, Lordship.
Yes.
Lordship, this is an application under section 482 of DNSS, your lordship. Your lordship will get the FIR at page 14. An amount of rupees 26,63,500 has been looted, your lordship, from the
I see you like.
informant, your lordship. May I read this, your lordship?
Yes.
I, Sri so-and-so would like to lodge an FIR regarding the incident of looting of cash that took place on so-and-so at 2:55 PM while the said vehicle was traveling from Dibrugarh to Tinsukia through NH 37 with Ramesh Kumar Agarwal, driver so-and-so. While returning from Dibrugarh, in between Hatiali railway station, DICOM, some unknown miscreants intercepted the vehicle and looted rupees 26 lakhs by threatening the driver and Ramesh Kumar Agarwal with dagger and pistol. The said amount was collected by Ramesh Kumar Agarwal on my behalf from the GS traders owned by so-and-so located at so-and-so. After collection of the cash, Ramesh Kumar Agarwal was returning to Tinsukia on the said vehicle when the incident occurred. The miscreants forcibly took the cash and fled from the spot immediately after committing the crime. Both driver and the Ramesh Kumar Agarwal were threatened but managed to escape without physical harm. You are therefore request. This is the FIR, your lordship. Now, subsequently during investigation, your lordship, police found that the driver of the vehicle, your lordship, who was with this informant, your lordship, he himself was the brain behind this entire act, your lordship. Your lordship will kindly come to page 18. That is the forwarding report of the arrested accused person, one of the arrested accused person.
The driver's name was?
Arjun Chetri.
Arjun Chetri.
He was found to be involved.
He was found to be involved. Your lordship. Now, the arrested accused person Arjun Chetri has misled the police after the incident. During the spot interrogation with the accused person, he mentioned that people who have done the robbery used a Maruti Suzuki Swift car. Your lordship will kindly note that. Page 18, last ground of arrest, which intercepted their Bolero and looted their money. Also mentioned that the robbers have turned around and fled away to the Dibrugarh side on the same AT road as per his statement. He has also followed back robbers' vehicle by the road up to Bokul bypass Tiniali. After checking CCTV footage, DICOM T State rail crossing, it was found that neither the robbers' vehicle nor the victims' vehicles appeared on the footage of their movement towards the Dibrugarh after the incident. It clearly indicates a criminal conspiracy in hatched by the robbers and arrested accused Arjun Chetri. During technical analysis, Arjun Chetri, it was found that he was number. This is there, your lordship. Now, your lordship, I am the person who is, your lordship, driving that Maruti Swift, your lordship. Now, Maruti Swift was taken on hire from me, your lordship. I was in the morning hours, your lordship, asked to drop one particular, your lordship, accused, your lordship, in Bokul. Bokul, Bokul, your lordship. Accordingly, I dropped him, your lordship, and I was paid some amount, your lordship. 2,000 and odd rupees, your lordship. Then I left, and thereafter entire incident had taken place, your lordship. This is so far as my on the basis of instruction I am submitting, your lordship.
Okay.
Now, your lordship, since that was there, your lordship, now police is also searching for me, your lordship. Most of the accused persons have been arrested, your lordship. I am before this honorable court, your lordship. And so far as I am concerned, your lordship, I was neither any money has been transferred to my account, your lordship, nor I am anyway involved. They have, one of the accused has hired my vehicle, your lordship. I have made a statement to that effect. That is.
For the forwarding report of this person, Sakya,
My lord.
they have shared the money.
Fine.
No, that is there, your lordship. He says, your lordship,
Remains to
that
be
money
seen.
was shared with me also, your lordship. That is there, your lordship.
Okay.
I was supposed
To be seen
to
then
show it
properly.
this honorable court. But your lordship, ultimately my instruction is that my role is limited to that. Rest, your lordship, what CBT reveals, your lordship.
If necessary, I'll go through it properly.
My lord, my lord.
Would you like to submit?
My lord, here is a sufficient, I was collected sufficient material, my lord. He is the mastermind behind it, my lord.
Who? This one?
That present petitioner, my lord. And
Not the driver.
when Arjun Shetty information given to the other person, other co-accused, my lord, they plan to record, looted the amount, my lord. And from the, my lord, case there reveals, my lord, a total 11,70,000 were recovered, already recovered, and 14,93,500 is yet to be recovered, my lord. And from the statement of the other co-accused, my lord, it reveals, my lord, how they have planned to, my lord, looted the amount, my lord. Here, all of the materials are against the present petitioner, my lord. And they have shared, my lord. He has distributed, he has taken two, my lord, toy pistol, my lord. And one, he has taken one, and another co has taken one, and looted the amount, my lord, by showing the toy pistol, my lord. And 14,93,500 is yet to be recovered, my lord. And in the next date, my lord, date of incident, my lord, some transaction were found from the, my lord, present petitioner, my lord. Even he paid 50,000 to SBI account, some of the person, and another 50,000 to his son also, my lord. And regarding, my lord, recovery, my lord, it was suspected that other remaining amount is in the hands of the, my lord, present petitioner, my lord. And he has distributed the amount, my lord, to all of the other accused person, my lord. One given to, my lord, 3 lakhs to 3 lakhs to, my lord, Modern Para Chetri, and 3 lakhs given to Dipankar Soikia, and 5 lakhs 7,000 to Raju Chetri, my lord. It is the, my lord, from the lordship.
In that case, your lordship, I leave it to your lordship.
My lord.
I have submitted on the basis of instruction.
But
It is
if
never a
PD
good
reveals,
idea.
your lordship.
It is never a good idea to travel with so much cash. Also foolishness.
My
Your lordship will go through and your
Any
lordship will
country.
pass.
Any
It
country.
is not a kick man.
Nowadays,
Maybe
you
your
don't carry
lordship.
cash nowadays.
If
so much.
your lordship, what my learned friend is submitting,
My-
probably this is not the case.
Anyway, we don't know. Let's see. As Botakur Learned Council, the step ID should take. And additional people for the state. Invoking 482, the petitioner is seeking PRS bill in connection with Sabua PS case number 89 of 2025. So, the case was registered based on an FIR dated 11/11/2025, lodged by one Rohit Agarwal with the allegation that Ramesh Agarwal and driver Arjun Chetri were traveling from Dibrugarh to Tinsukia with cash, with some money, and on the way they were their vehicle was intercepted, and the rupees 26 lakhs in excess of rupees 26 lakhs was looted. It appears that subsequently the driver himself was arrested and implicated, arraigned as an accused on the basis of some materials against him. Stop. The petitioner, Learned Counsel submits that as per his instruction, the petitioner had merely driven one vehicle and he is not involved in the alleged offences. The learned additional PP, after receiving the case diary, submits that the investigation has revealed significant incriminating materials against the present petitioner and indicating him to be involved in the alleged offense of the robbery, and even indicated him to be one of the main persons behind the planning and execution of the offense. This submitted that approximately rupees 14 lakhs is yet to be recovered, and Investigation has also indicated that part of the money is also is likely to be with the present petition. In view of such materials, and the fact that investigation is going on, it may not be prudent to grant anticipatory bail to the petitioner at this stage. Accordingly, the bail petition stands rejected at this stage. Return back the case.
Deeply obliged, Your Honor.
Investigate. Short break.
My please, Lordship.
Yes.
In this case, Lordship was pleased to grant privilege of anticipatory bail to the petitioner's Lordship. It is a charge sheeted case. So thereafter, they appeared before the Planet Trial Court, Committal Court, and they have been granted bail.
Well, the last occasion, Lordship was pleased to call for scan copy of the matter.
Yes.
Trial court record in city matter. Perhaps it is not available, it is not shown in the.
They have appeared already.
They have appeared and they have been allowed bail also. There was a compromise with settlement between the parties. And on that ground, Lordship was pleased.
Or should we wait for the scan copy or dispose it of?
They will face trial, Lordship. Committal procedure will follow, and ultimately, there is a settlement between the parties. Only 109 is there. 109.
109.
Does not.
118.
118 is also yes.
118 also.
And 140 is there.
Why should we wait for it? We can wait.
Reverse hard by sharp.
Huh?
Reverse hard by sharp.
Yes, yes, reverse it there, but on lag. So intention to
109 is attempt to murder.
attempt to murder is
We can wait for the scan copy or we can make it absolute.
they will face trial, Lordship.
Yes. Let's be back. The petitioners were granted interim bail on 19/12/2020 and scan TCR was called for. So, however, the same is not received. On the other hand, the learned counsel submits original certified copy order dated 5/1/2026 passed by learned JMFC, Silchar, Kasar Silchar. From the order, it's revealed that pursuant to grant of petitioners appeared before the state learned court and furnished bail bonds. They submitted that the petitioners shall appear regularly and face trial. In the circumstances, I deem it fit to dispose of this petition altogether. And accordingly, the interim bail is hereby made subject to the condition that petitioners shall be available for the trial. Shall not hamper or temporarily. Bail petitions stand disposed. You can take it back. You can take this.
Lordship, I am deeply obliged.
Original.
My lord, here we have not received the case diary. They are in interim mind.
Interim is there.
Case diary is not received. Issue reminder. Interim stands extended at the next date of list. List on
25.
25. 25.
25.
It will continue.
Highly obliged.
No.
Exclusive.
You're for the petitioner.
Yes, sir.
Mr. Chetri had appeared in the morning, the mentioned time, and said that that party has taken the brief, so he's no longer engaged. So he requested for deleting his name.
Lordship, in that case, his proceedings in the trial court may be stayed, your lord. Because I have already
You
made
can-
the payment.
You can make your submissions today. Yes, that is because you were not there at the time, so I just. So you can make your submission. What is this? You're seeking quashing of the complaint case.
NI case, your
NI.
lordship, 3777. What happened in this case, your lordship? A legal notice was issued demanding payment of 50,000 on (28/4/2023), and within 15 days, we have made the payment of 50,000. In spite of making the payment, they have filed this case.
So you are seeking quashing. He told me that he's representing, I think he made an error. Mr. Chetri said that he's representing one. One is not, one is a formal part. 2 and 3,
Yes,
North
sir.
Eastern Electric. Who's the complainant? Mridul, partner of Mridul Kejriwal.
Those
Complainant is Mridul Kejriwal,
Midul Kejriwal.
representing North Eastern Electrical.
Yes,
So he must be representing both of them.
yes.
So we'll have to wait for them usually, or otherwise we'll have to, issue a notice to them. Because the council has withdrawn. Right. So, thus, can we issue a notice? To be some kind of a court. So we don't wait for the here. The case is at the stage of.
It's not proceeding, your lordship. In the trial court, we are filing an application that the case is pending in High Court.
No, what was the last date? Where-
Last on January. It is fixed for necessary order.
And that's okay. But this cognizance has been taken.
Yes, your lordship. Someone was issued, so we challenge.
Thereafter, you can.
In fact, in their reply also, they have admitted that we have paid the amount.
Let's see, let them appear to the new council. Then it may be some of these matters may be possible to be disposed of at the admission stage. All are not. Some may be possible. So, okay. I will let them appear. We'll stay the proceeding in the meantime. You are Mr. Beria.
Yes, sir.
M. Beria, learned counsel for the petitioner. Also. Mr. K.D. Chetri, representing respond number 2 and 3. And within bracket, the complaint had made a mention that the litigant has that the file has been returned to the litigant and that he is no longer engaged in the matter. And that he seeks to withdraw his wakalat. It was further submitted that his name may be struck. We issue a notice or wait for them. They may come on their own. The respondent side, respondent number 1 and 2 complainants may. Sorry, 2 and 3. 2 and 3. Actually, in some check cases, 1 is not necessary. So they implead, isn't it?
Formal party.
Should I strike it off? But let it remain since nobody, they also not represented. But actually, it's a complaint case.
Complaint case.
Anyway, I'm not striking off.
My lord.
But
Formal party.
It's not necessary. Already you have enough load. The respond number 2 and 3 being the complainants may appear the next day through their new counsel. Mr. Beria submits that cognizance has been taken in this case, and case is at the stage of appearance of
Yes, appearance.
appearance.
Necessary.
In the circumstances, it is submitted by the learned counsel that despite admission by the complainant side about the payment, the instant criminal petition has the instant check bouncing proceeding has been filed, and therefore the petitioner is seeking quashing of the same. Till the next date of listing, further proceedings in CR case number 3777, right?
Yes.
Of 2023. There's huge load of check bouncing cases, and this also contributes. We have special, some of the magistrates are dealing exclusively almost special courts. They are still sitting in the court of learned GMFC first class. Any number? No.
Number 1.
Number 1. Kamrup M. Guwahati shall remain state court. This is the matter on. You can take a day on the third week of or fourth week of February. Okay. (28-2). Is it okay? Sorry. I've seen that. Sorry, I saw the calendar of January. Let it be on 26-2.
Machu.
Criminal.
Well, here it is the jail appeal,
Jail
my lord.
appeal.
Lordship may appoint some
Amicus we have there.
P. Sharma is also here, my
Huh?
Vijita Sharma is also here, my lord.
Huh?
Am I correct? Vijita Sharma is also here.
This jail appeal has been preferred by convict appellant Hiren Pao against the judgment and order dated 14/8/2025 passed by the learned session judge Lakhimpur in sessions case number 88 of 22, whereby he was convicted under section 326/307 IPC and sentenced to undergo cash custody. RI for 3 months under RI for 3 months for conviction under 326 IPC and RI for 7 years and fine of rupees 10,000 within bracket in default RI for 6 months bracket close for conviction under 307 IPC. The appeal is admitted for hearing. The call for the original TCR of sessions case number court of that session just looking. Vijita, you filling? P. Sharma, learned the council is hereby appointed as amicus to represent the appellant. No notice to inform. POCSO.
326.
The registry shall furnish a copy of the relevant documents to the prosecution as well as to the learned.
Obliged.
List matter. The orders follow on after a month.
After a month, after 4 weeks.
The TCR, na? After the receipt of TCR.
After receipt of
Receipt of TCR.
after receipt of the TC on a date to be fixed by the registry.
Right.
Right.
May I please, Lordship? My lord, my senior is not well today, my lord. Maybe taken up, my lord, next week, my lord.
First week of February, my lord, any day, my.
And counsel, you could. On behalf of,
My name is Dia, my lord.
no, yeah, yeah. Okay.
Ishak.
Yeah. Otherwise, it is, record is come,
Yes, ma'am.
record is come.
Record received, my lord, already received.
Okay, I'll give you the adjournment, no problem. But can we, should we remain at the admission stage only?
Yes, my lord, admission is my.
Because some matters cannot be disposed of, some matters can be disposed of. I have not gone into what is it side. All matters, some matters should be heard, fixed for hearing also. Some matters should be admitted also. The problem is that hearing takes its own time. That is why councils are reluctant. So I understand that. But we have to find a solution to that problem. I'm also at a loss what to do. Anyway, so seeks an adjournment for the day, which is allowed. It appears that the scan record has been received. What about the other side?
Appear already.
They have
Service.
appeared?
Service.
Otherwise, we can do some homework in between. Oh. Let me see. Cross-check.
Yes, my lord. Service completed, my lord. That's why, my lord, it is listed for admission, my lord.
As for office note dated 1911, let me record it because it's not mentioned. Office note dated 19/11/25. Service is complete upon respond number 2. The scan TCR has also been received. List the matter in the admission column on
5th of February, my lord.
little later. Little later.
Late, my lord.
A little later. Third, you take it in third week.
10th of February, my lord.
Can you take it in third week if you don't mind? Take it on 16,
16th, my lord.
okay?
Obliged, my lord.
Or any other comfortable day. Because we have fixed many matters.
Yes, my lord, 16th.
Or you take it on 13th, 13th or 16th.
13, 1-3, my lord.
1-3. No, you take it on 13th or 16th as per your convenience.
My lord, 16, my lord. High level.
16.
Item 31.
May I please also? My lord, as per office note dated, my lord, 28/11/25, my lord, ID card nor unserved notice has been received back, my lord. Whole case.
All matters.
Whole matter.
These are against conviction.
Against conviction.
Oh. Those matters are, they are usually fixed, admitted and kept for hearing, and they're pending for many. See, appeal only is from 2012.
Yeah, 2015. Or fix the matter for hearing also. Yeah. Because the check amount is only 2,000.
2000.
Only 2,000, my lord. Check amount is just only 2,000. That is why, my lord, they may not be
No,
interested.
for some, no, I'm not laughing. I mean, for someone, 2,000 may be a big amount.
Minor, but
Not
procedure
like
is
that.
to be followed.
But
Yeah, my lord, we might have
2,000
to
check and we have, in
Minor,
our
procedure is-
system, it is pending for ages,
Minor.
you know. So
So
we
either
are
we
also
take,
at fault.
either we take fresh step or
Here one of these days and finish it, but you have to complete this. The matter is pending for service of notice upon the respond number 2 complainant.
yes,
No, respond number,
my sole respondent.
sole respondent.
Sole respondent.
Who was the complainant in this revision arising out of the check bouncing procedure. Take fresh steps.
Fresh steps.
Petitioner said take fresh steps upon the response. This is a Adgaon address.
Yes, whatever address is mentioned in the complaint petition, in that
It
step.
will be agreeable to do dusty service also.
Dusty service, my lord.
Because it is a, if the person is actually in this, very easily reachable. You know?
Other than
Not
my
complex,
lordship,
Adgaon,
direct, direct both dusty service and research.
Both, yeah.
Yes.
The petitioners will also take dusty service. submit a compliance there. If you can find the person, then
Yes, yes.
we can hear it. Please the matter, the audit column on. When choose the date,
Obliged.
take the date. You take the date. Date is, I have not given the date.
March, man.
February only, let's fix it. 23/2.
23/2, my lord.
Justice service, if it clicks, then it will.
Because registered in.
If you can resort to justice, if you find a person,
Yes, sir.
we can done.
Yes, sir.
Then we need not bother about this.
23/2.
23.
Bless.
My lord, this is also a long pending case,
Yeah.
2016.
Mhm.
And
He's
it
on-
will, my lord,
He's on bail, hopefully.
he's on bail, my lord. But what has happened, my lord, earlier, twice or thrice, my lord, the notice was, my lord, taken on the respondent too.
Mm.
But there is a default on our part, perhaps there is an office order, there is an order of 25. My lord, fresh steps were directed to be taken. My lord, in fact, the address, my lord, I think, my lord, could not be traced out. What I think, my lord, would be pragmatic, further, my lord, to
Poxo
expedite the matter, POXO Act. Your lordships can, my lord, engage one amicus curiae, since your lordship is doing this, my lord, so that my matter can be sorted out. That there are panels of amicus curiae, my lord, for POXO Act.
That's the easy part.
That can be done,
Without
my
notice, can I appoint an amicus?
But
Without service.
notice has to be served by the.
I have taken steps, my lord, earlier.
Notice has to.
There are, my lord, evidence.
If after serving notice, my lord, nobody appears, then lordship may appoint amicus.
Usually I
My
have
lord,
seen that.
That is my.
You can guide me if,
My-
if
No,
without
I can
service,
take fresh steps, my lord, because
no,
since it's a long pending case,
that I also
Yes.
move on.
Yes,
Because, okay, and
there is no problem, my lord,
if
taking
it's
steps.
possible, if there's no, if there's no procedural irregular
Right.
appointing an amicus without the service,
Right.
then I can, but the practice I have seen is that.
My.
In that case, my lord, I can take
What
a
should I
fresh
do?
steps, my lord, no
Yeah,
problem.
guide me.
Yes, yes, no problem.
Taking steps is easy, but whether it
My
is
lord.
served or not.
Exactly, my lord, I'm on that.
Do one thing, what do you do? You take one fresh steps,
My lord.
please, and they will take instruction.
My lord.
from-
From officer in charge of the concerned
Yeah,
case.
to the concerned OC. And irrespective of that outcome, whatever happens,
Man.
we'll appoint an amicus.
My
Correct,
lord, my-
correct,
that is.
correct.
Officer in charge.
Lordship will reflect in the order, my lord. That
From
will be-
officer in charge of the
Yes.
concerned.
Yes, I'll.
Yes, yes.
Also, the appeal is pending for service of notice upon the respond number 2. Informant. Informant. Respond number.
Respondent two, my lord, correct.
Respondent 2.
Yes,
Fresh steps may be taken on the said respondent. Through the office of the public prosecutor.
My. Officer in charge of the public.
He'll
তোমালোকক খালি
submit
যাব লাগিব ন?
and will be executed
My lord.
through the concerned police station. The prosecution shall also take the necessary instructions subsequent pertaining to service of notice. Thereafter we can,
Deeply aware.
and even if it is not, we'll, this time we'll move on. List the matter on. List the matter, please take the date.
My lord.
My lord.
Date.
List.
At least 4 weeks may be granted, my lord.
So 27 February. last-
My lord, correct. Obliged.
Also, you are also in the same problem. Notice answer, POXO, same order will pass, same POXO, 3 years conviction,
We
7,
follow the same.
same. We'll give a copy to the PP's office,
Chalukar learned
from there they will serve it.
phone number. Thereafter we'll take an amicus and move on. We'll
Okay.
appoint amicus.
My lord.
30, huh? Same day.
Same date, same date.
Lordship 20. That was fixed on
27.
27 February,
Same, last two matters, 27.
March.
Please, your lordship. Lordship, service in respect to respondent number 2 is complete. But lordship, by order 38/2019, we are directed to take fresh steps on respondent number 1, who is a retired bank official and has been residing somewhere in Delhi, lordship. With our best efforts, we could not get his address, lordship. I would pray before lordship to allow us to opt for superior mode of service.
Bank official.
Yes, lordship. He's residing in Delhi, so
It's a appeal against acquittal.
criminal appeal, lordship.
acquittal.
Yes,
Yeah.
Lordship.
Acquittal.
Acquittal.
Complaint case. I think the court, what you are suggesting is the only option, it seems.
Yes, sir.
I feel. Let us see. First item. Yeah, it is a check case, check bounce.
No, Lordship, it is a complaint case. Check bounce case was against us, Lordship.
Oh.
We were acquitted.
Right.
It is a complaint.
So, against this, Horesor Das, sir,
Lordship, sir. Respondent number 2, sir.
Yaruddin Ahmed,
That is
branch
the
manager.
branch manager, Lordship,
No.
Punjab North. He is retired, Lordship.
Her notice upon, full stop, as reflected in the order dated 38/2019. Notice upon respond number 2 has been served. He submitted that notice upon respond number 1, bank official could not be served as he is retired and resides in Delhi. And that the petitioner has not been able to collect, appellant has not been able to collect the address. The same is also reflected in the said aforesaid order. The learned counsel for the appellant seeks liberty to resort to substituted service, prairie cell. Substituted service may be resorted compliance with the Thereafter we go ahead.
Okay.
This is the matter on
In the month of March, sir.
2nd March, 2/3.
Obliged, Lordship.
LCR, everything is ready.
My pleasure.
Case is listed almost after 10 years, 9 years. Lordship.
Hmm?
My instruction is that both the parties are
Last,
using this-
last listing was in 26/7/17.
17. So my instruction is that both the parties are living peacefully, Lordship, as of now.
Hmm?
So, let's say it's not present.
Actually, this kind of, we should now, we can use technology nowadays so that we don't lose track of any cases in the system. It is possible. I'm not even talking about AI. You use AI to is there. Of technology, they can, you lose track so that we don't lose track. I'll talk. The appeal against acquittal.
According to 406 case.
Who's for the appellate? Nobody. Not it.
Who is their parties?
UA acquitted. UA acquitted. Your
Acquitted.
your client was acquitted. So pending unnecessarily, I think. The this appeal just a minute. He was the complainant, informant. She was the informant.
Complainant.
This appeal against acquittal has been filed by the informant. The appeal was admitted on 26/7/2017 itself. So, the LCR is there. That's LCR. LCR is not come. ECR is not come.
There's a occasional file.
Oh, here is not yet been received. The PCR has not yet been received. Issue reminder for the PCR of CR case number 2245 of 2012. Finding these cases or records are also a challenge. Overloaded method from the court of the learned JMFC Kamrup M. Guwahati. None appears today on behalf of the appellant. However, learned counsel for the respondents. Respondent number 2, 3, 2, 3, and 4 is present. Your good name, please.
GRA Muttaki.
G?
GRA Muttaki.
List the matter, the orders column. It's better to fix a date. Better to fix a date. 26/2.
Right.
26/2.
36.
My lord, I'm not associated with this appellant copy right now, Lordship. I have
Anymore.
already returned the briefs, Lordship,
Anymore.
long back.
See, many of these order matters they find it difficult to get reached.
Man.
See, today we have slightly lesser, so we are reaching, but so many important things are pending.
Minor.
Right? So it's very important for all matters to get reached.
Minor.
So at least we know, we can at least look into it. What is the problem?
And Lordship, in this case, I don't think the company would engage a new counsel because they are not traceable right now.
This
And amicus curiae may be appointed, Lordship.
that is one option. Never mind.
Unnecessary delay will be there. Amicus curiae, pumping nine.
It was against acquittal.
Yes,
Acquittal.
yes. The finance company.
Have abandoned. This appeal against acquittal was filed by the complainant company, has been filed by the complainant company. Stop. None appears on behalf of the. Respond number. Respond number 2. Udhen Gogoi. TCR. The TCR is available. Learned counsel, good name.
PJ Burman.
PJ Burman submits that is no longer associated in this and that the brief has been returned. His name may be struck off from the list of the
Along with me, Lordship, I think another council lawyer, P. Fukon, that may be struck off.
P. Fukon.
Yes,
Both the council.
both the council may be struck.
The names of PJ Burman and the listing council P. Fukon may be struck. So what do we do? Issue notice to them, to the complaint, or as
I
you
don't
said,
think they are available at the present address, Lordship. Yeah, as per my information, they have changed their office, and right now I don't think they are operating in Guwahati. I think they are operating from Calcutta right now. And I don't have any contact number because all have changed. I have lost also some
Yeah.
contacts.
earlier they used to be in Guwahati.
Yes, in Hattigao, Lordship.
Hattigao. Into the Leland Finance.
Lordship, if you say Lordship, a notice may then, but I don't think it is operating there. I heard that they have changed their office and right now they are operating only from Calcutta. They have they have minimized their working staff because of the COVID. Lordship, this company very much financial loss.
So I think
So
let us
they-
do the procedure.
Yes, that's part of
Issue a
procedure. Lordship.
notice may be issued upon the company at its address, at its stated address. to appear through its new counsel if it is interested in pursuing this proceeding. List in the orders column on 27-2.
Lovely.
Necessarily pending. It shows in the docket, right?
Right.
All these. The entire life cycle of litigation has to have a no, expiry date. It has to
Right.
come to an end.
37.
Lordship, as per the last office note, trial court records have not been received. A reminder may be issued, Lordship.
Yes. This is also a negotiable instrument, right?
Yes, Your Lordship.
Equital.
Yes, Your Lordship.
Your good name, please.
K. Bhattacharya.
K. Bhattacharya, Land Council for the appellant. First up, the appeal. This appeal against equital been filed against judgment and order dated 6/12/2016 passed by learned JMFC Kamrup in CR case. Kamrup, which one? Metro? Metro? I think. Bamuni Meda. New Guwahati Metro. In CR case number 1189 of 2014, whereby the respondent as accused was acquitted. The TCR has not yet been received. Issue reminder for the TCR of CR, original TCR of CR case number 7 from the court of learned GMS. Wait for them filing also. Anyone appearing for them for the opposite side?
Service is complete,
As
Lordship.
per order dated 10/12/2018, service is complete as regards the sole receipt. So, however, none has appeared today on behalf of the said respondent. This is the matter on 2 March.
So this is also appeal against equivalent NI case. The other side has entered appearance, Lordship. And moreover, TCR has also come, so ready for hearing. Next month, the Lordship may fix the date of hearing.
Set it for hearing. You are the complainant.
I am the complainant.
The learned counsel appears for the appellant, who is agreed by the judgment and order of acquittal passed in the proceeding under 138 negotiable instruments. Learned counsel.
A Lala.
A?
A Lala for respondent number.
Yeah, respondent number 2. Yes. The TCR in original.
No, respondent number 1. One of them.
One.
One.
Respondent. The original TCR has also been received. So we can fix a date and
Fix a date next month, it's February.
you can such as per your convenience.
As your Lordship.
No, I think it's better you choose. Hearing man.
On 19 February, 19 February.
This one.
It's a Thursday.
Thursday, 19 or 24. Tuesday.
As your Lordship, please.
20.
24.
24 too, right? 24.
Marks out.
39.
May I please, Lordship? So we are taking fresh steps, Lordship, but the issue is, Lordship, the informant was a Havildar in the year 2013. But presently, we don't know where he is.
Just a minute. It is the order is under stay. The proceedings are under stay.
Yes. The PP also can appear for respondent number 2, as he was Havildar. Informant was the Havildar, Lordship.
It's a wildlife case,
Yes, Lord.
2016.
Yes. Lord.
No, yes.
ল'ব পাৰে নহয় মোৰ কথা হ'ল ইনফৰমেণ্টজন পুলিচ আছিলে মানে কৈছো মানে প্ৰাইভেট হেৰি হোৱা
Chandan Deka is, he's served.
No, no. Chandan Deka and Hemanto Deka, they are petitioners, Lordship. And response number 2 is Tiken Talukdar.
He can go us. He can look.
Yes, Lordship.
Who's a Havaldar?
Yes.
Yeah, he can represent.
Special wildlife.
Was it a complainant?
If there is a
He
wildlife,
was the informant. Lordship.
So, wildlife.
if wildlife,
special
মানে
PP
there
is
is a special PP, my
Special
lord.
people.
Special PP.
But I can pass on all.
But their name may be reflected.
No, no, why? Special PP is there.
For special.
Special. Your good name?
MJ Gogoi, Lordship.
MJ Gogoi, learned counsel for the petitioner who had filed this revision against the order dated 22/2/2018 passed by the learned additional session judge number 3, Group M, in sessions case number 173 of 2017, framing charges against the petitioners under section 51 of the Wildlife
Fine.
1970.
You copy.
The case is pending for notice upon the respond number 2, Tiken Talukdar, that was then was a Havildar at the relevant time and informed the learned special PP for the Forest Department for looking after wildlife crimes can also represent the respond number 2.
Their names may be shown in the cause.
So that this whole matter can proceed, whole pending matter can proceed. The name of the learned special people representing respond number 1 and 2 shall be reflected in
The cause list.
next dates, from the next date reports.
The date may be fixed. Lordship.
Yeah. (26/2).
26. Oblige, Lordship.
Stay order is there.
No, there is no stay.
There is no stay order.
No.
But the case is
It's pending since then, Lordship.
without stay order.
Because of
Record also not here, man.
yes, a record.
Whether a case is completed in there, it is a 2018 matter, man.
Yes, currently on evidence is placed, Lordship.
Evidence.
The
Yes,
time is
it-
like that, I'll tell you.
yes.
Samar. With time now, everything we also forget.
If Lordship thinks fit, then stay may be
No,
granted.
no, it is a careful minor. Careful of minor, that is.
Actually, notice was not served to respond number 2 at the time. That's why it was
So
not
what we'll do,
passed.
is the scan copy, it's not received, no?
Same copy not.
We'll
LC
call for scan copy.
Yes,
only.
LCR may be.
Call for the scan TCR of sessions case number so and so, in the court
Yes.
of learned additional session. Date will remain the same.
Oblige, Lordship.
Okay.
Yeah, please. The old pending matter, Lordship, TCR is not received, Lordship. Lordship, in this case, as per public notification, Lordship, the respondent number 2 is not required, Lordship. At that time, 341, 324. 341, 324.
What notification?
That only in POXO case and gang rape case, in that only the 2 is required. Otherwise, in some of the case, Lordship may strike of the respondent 2, Lordship. And TCR may be called.
Your Mr.
SK Chetri, on behalf of
Learned
Ainuddin.
counsel for the petitioner submits that considering the nature of the penal provisions involved, perhaps respond number 2 may not be necessary, and that the case has been pending for notice upon service of notice upon case is pending for that.
Yes, Lord. And TCR is not received, Lord.
And for the respond number 2 also. I find force in the said contention. So stop the respond number 2 and maybe stop. In the meantime, call for the The revision against conviction.
Yes, Lordship.
Undergo simple. We can.
They will shoot a court, Lordship, from the GMC court, London GMC court and London Session court.
The call for the scan TCR of GR case number 1391 of 2013. And we will require the appellate record you don't need. Appeal memo is here only. The appellate judgment is here only.
Yes, Lordship. We have enacted the judgment, Lord. Excel B.
Appellate judgment.
Yes, Lord.
GR 1391 of 2013 from the Court of the Learned GMFC Gwalpara.
Yes, Gwalpara.
Gwalpara. Leaves the matter on 3rd March.
Yes.
Sorry, not no, 3rd March is a holiday.
5th or 6th.
2 March. 2.
Oblige.
Remaining matters will do it.
Four, five matters left.
Huh?
4, 5 matters left.
We'll do it.
Lordship, today
Yes.
we have taken steps upon respondent number 2.
Okay.
Matter may
Foxtrot?
be taken up
Yes.
after 2 weeks.
Up to 2 weeks. Uh,
Six.
the main appeal or the IA? Yes. Yeah. Learned counsel, your good name, please. Your good name, please.
He does.
Learned counsel, please. Learned counsel for the appellate. Submit the steps of notice have been taken upon the respondent number 2 informed. Praise for listing the matter after 2 weeks. Prayer is allowed. Should we fix a date? Is after 2 weeks. The original TCR has been received. Has already been received.
Yes.
This is the matter. You want a date? Should I fix a date?
Wanted it. After 2.
After 2 weeks, or a date to be fixed by registry. Fix.
Time being at a fail.
It goes over.
May I please your
Yes, I remember. It's not come.
Must be some the
Okay.
not we have not. I'll have to require it.
Okay.
That will be fixed after
Next
in
week.
the next.
You will not file any reply.
No, Milan, not required.
Can TCR is available. However, admitted the objection filed by the prosecution not yet come into the record, perhaps due to some defect, which will be addressed. This is the matter. You can take a choose a date.
4 will. 4
Four,
February.
four.
4.
I have it.
44.
By this lawsuit. So, sir, this criminal petition against the judgment of Malad Family Court Borpeta Malad. State is the formal party here. Earlier, 2 occasion we have already taken steps to the respondent. Not appeared. Subject of lost permission, though they are not appeared, I would like to submit few lines in favor of my case because my case is purely on the law point, Malad.
Just a minute. I'll hear. Service is not complete,
Not complete.
not yet. No, that's fresh notice upon speed post. Return answer. Addressee left without instruction. Seems she is not there at that place, at that address. It appears.
My lord, that may be. One thing here, my lord.
You tell me. Your commission.
Actually, we are against the impugned judgment passed by the family court, Borpeta, my lord, whereby respondent number 2 was allowed to pay monthly 5,000 maintenance, my lord. And in the, my lord, Honorable Supreme Court, my lord, 2021 two Supreme Court cases 324, Rajnath Singh versus Neha Nanadas. In this case, my lord, paragraph 64 clearly stated that if any family court decided a case without perusing the assets and affidavit in assets and liability, that has to be, my lord, set aside. That judgment has
Is
to
it?
be. And in this case, my lord, learned family court decided this case, my lord, without submitting assets and liability by the both parties. So I am basically, based on that ground, I have challenged that judgment. And there is a violation of law is there. My prayer is, my lord, kindly remand back the matter.
Suppose sometimes no, they have to be directed to file their assets and liabilities. They have to be directed. Sometimes I've seen in my practical experience that sometimes one party never submits. So in that case, the court has to go ahead. But they have to be asked. But let us see what is there in the 60.
In the judgment, my lord, nowhere mentioned about such direction.
Should we see the paragraph 64?
Yes, my lord. Paragraph 64, judgment on earlier occasion I have placed before your lordship, probably in the.
It is here.
My lord.
I'll just have it.
64, yes. 64 and 65. 65 kindly peruse.
Is not, yeah, this is the law that they should be declared, but it is not really said that if it is, if the order is passed without the affidavit, then it will be liable to be set aside. That has not been said, but it is a direction as a mandatory requirement.
Yes, mandatory, my lord, mandatory.
You can indirectly you can say that.
Yes,
What
indirectly.
you're trying to say. Indirectly you can say that.
So, based on this.
Because the court has said it is a mandatory.
Mandatory, yes, says mandatory. And based on this judgment, our Honorable High Court's coordinate bench of this court, my lord, passed several judgments, out of which, my lord, one judgment I have placed, my lord, criminal petition 65625. And in this judgment, the coordinate bench of this court clearly, my lord, says that, yes, without assets and liability, family court cannot decide the maintenance case.
Provided it is submitted by the parties.
Yes,
It to be asked to submit.
Yes.
Despite that, if they do not submit, then it's another.
Yes.
Then the court has to move ahead.
Yes.
But in any case, what do we do? Should we wait for the notice? I've understood this law point will address, but now should you have taken steps?
Yes, 2 times taken steps.
What to do then? Is a mention about limitation or what is the just said in the earlier order 27 limitation.
There is, my lord, on a delay is there on that ground, my lord. Family Courts Act 17, I think, my lord. On that point, some
delay
observation is there.
Delay revision is 90 days, I think. 90 days. Not 60 days. 90 days. It is mentioned 60
criminal
days.
petition, my lord, 482. So here is, my lord, delay is not applicable. If lordship revision in respect of revision, that is another, my lord.
Revision. It's not a revision.
It's not a revision, my lord. Criminal petition 5.
Limitation Act does not have that category.
Mal-
Criminal petition. So, what do you suggest?
Actually,
You can take press steps or you can take substituted service. But ideally, procedure will be, it's like irregular if we do not proceed this point.
and some difficulties to take fresh step, my lord. If I take again step, my lord, that will be remain same as in the office note highlighted that she has left her address. So how in this situation, my lord,
Only
can we-
option is to paper notice, newspaper notice. Yeah.
newspaper notice, my lord?
What else? You can suggest. Dusty service you can try. but
Dusty,
if
Dusty,
she's not there,
Dusty very funny. Dusty, my lord. I will try for Dusty.
try Dusty. No, but from this postal remark, it appears that she's not there.
Yes,
Not
yes.
staying there. If she's staying there, then Dusty will solve your problem.
Yes, my lord. One difficulty
Okay,
is
take a
here.
chance with Dusty.
Yes, yes. We'll try for Dusty.
Okay, Mr. Azad, Learned Council
Oh.
submits that those steps have been.
Oh, my lord. Sorry, my lord. One thing subsequently we came to know, this respondent number 2 subsequently solemnized marriage with another, and now she is residing her second husband house. So her second husband, address of her second husband's house not mentioned here. So in I have to serve notice on the her their address. And in this situation, what can I do? Amendment? In that situation. Now she has left her address and she is starting to reside her new husband, sorry, second husband.
You want to amend?
I think without amend, it's not possible to take steps because in the my postal that address not here. Thanks for good.
So steps of notice, submit that those steps of notice have been
I have to amend better. It will be better amendment.
been taken on the respond number 2. Second / first party. On 2 occasions, but it has not been successful. As per office note dated 23/12/25, the notice has come back unserved with a remark addressee left without instruction. Learned Council submit that as per their information, the said respondent lives at another location. And therefore necessary amendments may have to be made in the cost type.
Well,
you can do that. The
it
same
will
may
be-
be done.
Yes, yes.
For remembrance and just Learned Council also submit that his main contention is that the impugned judgment was passed without the affidavit of assets and liabilities, which has been held to be mandatory as per paragraph 65 of Rajneesh versus Neha 2021 2 SCC 320. For remembering.
Yes, my lord. Yes.
From another bench also.
But, one thing I would like to, my lord, pray more. Kindly LCR maybe call for my lord in that time.
LCR will be necessary. Not
Yes,
come.
LCR not come. LCR maybe call.
In the meantime, call for the TCR of FC criminal case number 151 of 2020 from the Court of the Learned Principal Judge, Family Court, Corporate.
Yes.
Please the matter on.
Any date, my lord.
You can suggest the date. Suggest.
After last week of February, if possible. First week of March.
2, 3.
Yes, my lord. 2, 3.
Oh.
45. I'm obliged.
Yes.
Please, Your Lordship. Your Lordship, as per office note dated 28/1/2026, the service report still awaits on respondent number 2.
Yes. Washing of FIR and charge. Miss Archer, Learned Council, admits that as per office note dated 28/1/26, service upon respond number 2 is still awaited. So we'll wait for it or wait for some time. 25 minutes. Anything in the IA? Yes. Await. This is the matter after 3 weeks. After 3 weeks on a date be fixed by the case. In case it does not get listed, you make a mention.
Obliged.
46.
Please, your lordship. In this case also, your lordship, service report not yet come, your lordship. I think TCR come, but opposite party number 2 not yet appear, your lordship.
TCR is 10 copies.
My lord. So your lordship,
Washing of
either
copy.
wait, my lord.
Sure.
Wait for service report.
Wait for service.
Fix a date, your lord.
The scan LCR, TCR has been received. However, service upon respond number 2 is pending. Await
Party number 2.
respond number 2. Await list the matter on. That's by your convenience. You can suggest me a convenient date.
Or maybe 27 February, your lord.
20 okay.
Master.
Yes.
My lord, this case is lordship regarding quashing of the affair. Very unfortunate lordship. The case has been registered under section has been registered under
109.
section 109, but the forensic report reveals that the wife of the petitioner died due to jaundice and this hepatitis disorder. I'm holding the forensic report, which is certified lordship, certified copy. And this man, because of this case lordship, was arrested, and pursuant to his arrest, he has been placed under suspension also. He happened to be the Gao Pradhan of that village lordship.
Now reinstated? No.
No, not reinstated because of the pendency of this case.
Yeah.
That is the that is what little urgency in this case, lordship. We have filed an additional affidavit yesterday. Probably that has been not checked. Annexing the
Scan record is
annexing the lordship forensic document, lordship. Probably that forensic report will also reveal in the case record, lordship.
Here regarding the article quashing matter, then we will have the matter this report matter.
In panel cases, this sort of cases, for the notification, is it mandatory for the?
may not be.
Yes, because
of quashing matter.
Washing.
Or
Oh,
quash.
then it means.
Matters. If it is in the bail, that is
Ah.
something, but here is the
Yeah,
quashing matter.
yeah,
this is not-
he may be agreed. Anyway, so service has not, it has not come back.
Here one report we have this matter, but it is completed.
Service
It is-
report in respect has not yet been received back by till date of. This is 28/1/26. Is a 28/1 recent, therefore is all to CPS.
presumed to be completed.
So your
service.
line of argument will be something like that, that since the forensic report is like this, therefore it was not justified to file the charge.
Yes,
Only.
lordship. Yes, lordship.
See.
So it's a gross lapse on the part of the investigating team, lordship.
Mohan Kolita, what is this? Yes, how did you get it? You have got, it came back to you.
Lordship may post it for admission hearing in the coming week, lordship.
Okay, so what do we do this, because it reflected in the registry note that it is not awaited, so this I can say that you have submitted.
This is also in our record.
Record.
But
Yeah. Can we do something about placing this before the registry somehow?
sometimes it is sent to our office. Sometimes send to the registry, that's fine. I will verify.
But I will record your submission. Stop. This Som Learned Counsel for the petitioner submits that an additional affidavit has been filed, bringing on record an important document, but it has not come into the record. The additional affidavit, along with the annexer, may be brought into the record. The case is also, the scan record, TCR has been received. The service upon respond number 2 is awaited. In this regard, the learned additional PP submits that a report has been received with the signature of the respondent number 2, Mohan Kolita, from the and he undertakes to verify the said service. You verify it. Thereafter, it can be. Should it remain at the orders column? only?
No, Lordship, it will
Because in
kindly be
because-
posted for admission hearing. May kindly be posted for admission hearing, because this presumption can be drawn, Lordship, that
No,
service is completed.
I was
Yes.
thinking that if we take a short date and get this verified, then we can fix it for admission. As you wish. Leave the matter in the admission.
And second then, second, just he will take that
It
information.
will be better to fix it on 3rd or 4th.
Third, I'll be having some fourth.
Fourth. List in the orders column on 4th. But the problem is that today we are, we could reach, because matters don't reach, no? That's the problem.
That is a
In the long race.
difficulty.
Because order matters also has, in orders also so many important things are there.
Important things are there, Lordship.
Things are there. All matters are on this. Anyway, so after it is completed, we will hear it at the admission stage.
48.
Amla.
No.
Amla is the.
May I please, Your Lordship? My lord, criminal petition for quashing of a proceeding, my lord. Service is completed, my lord, as per first list, my lord. Legal aid has been authorized, my lord. TCR also received, my lord.
Also, may fix it for admission hearing.
Yes, my lord.
Legally, not required, but trial for record.
Third, for the petitioner, additional PP and B, amicus curiae. For the legal aid counsel for respond number 2. We had done some hearing on this.
Yes, my lord. Stay order is there, my lord. Interim order date 7/1/2026.
The scan report has been received. We'll fix a date for admission.
Yes.
This is the matter in the admission column on. You can suggest a date, not hearing the other date. Finishing the
convenience,
bail,
Lord.
we can do. Hearing date, we should give priority to hearing.
As per the convenience of the court, my lord.
24th will be hearing day, visitor. So 24th, 25th.
My lord, interim order date is
Interim
7/1.
Then extended in the next date of this. No
Oblige.
Okay.